Hi, everyone. This is Susan. I am going to be leading our custody trial skills training. I'm a legal support coordinator at Philly VIP, and we have two lovely presenters today. We have Ms. Arly Smith-Pearson and Ms. Emily Vener. They're up at the front, and they are going to be providing a lovely training for us. We are recording this training for posterity, just so that everyone is aware. And to get started, we're going to talk about Philadelphia VIP and some of our stats and just information about our pro bono cases in Philadelphia. So, as the slide says, Philadelphia is the poorest big city in the US. What that means for us and for our clients is that they really need assistance with free legal services. The demand for those free legal services is far higher than what we can cover, but we do our best to try to bridge the gap there for our citizens. And part of that is working with volunteer attorneys to take our clients' cases and help them in situations where they really can use the legal assistance, and also they benefit from it much more than if they went to a hearing, for example, without an attorney present. These are some statistics on VIP's numbers for our cases this year. In 2024, VIP volunteer attorneys assisted in 42 custody cases, but as you can see, we received 230 requests for assistance. We receive a lot of clients that need help each year, and we have also seen that clients that go by themselves to hearings usually do not fare as well at their hearings as they do as if an attorney is present. Usually we find that just having an attorney there with the client to support them and advocate for them in front of the judge makes a big difference in their ability to get closer to their goals for their custody case. Something we also like to point out is that our volunteer attorneys can always limit their representation through their representation agreement. So we only ask that volunteers take on the case for the single hearing that the case is presented on the website with. So there's no need to continue representation beyond that date if the client has a continuance or something else comes up, unless you want to do that, which we do encourage, but you're not obligated. And I'm going to hand the presentation over to our presenters now. And they're going to talk about the basics of custody and how to get a case started and handled in court.
Thank you so much for that introduction. And I'm Arly. I work at Philadelphia Legal Assistance, and I would be remiss not to add on to Susan just that about 90% of the litigants in Philadelphia Family Court do not have an attorney. And so the vast majority of people who are needing assistance cannot afford it, and they're doing this by themselves. And so if you're thinking of doing the case, think about, you may be nervous, but you understand basics, understand procedures, you have language skills that many of these clients don't have. And so having you there puts a litigant so much far ahead than they would be without you.
I would agree. I'm Emily Vener-Giszter, and I'm a VIP volunteer at a small firm in Media, Pennsylvania, and I do mostly mediation and some family law.
So we wanted to start out just checking in to see where our people who are at the training today, what kind of experience you have, what you're hoping to get out of the training. We know you're on mute, so if you could add anything into the chat and Susan can read that. And we have Elise here in the room, so how don't we start with you?
Hi, I do have experience in family law and custody matters, but it's mostly been just drafting documents and stuff and not appearing in court as much. So that's really what I want to focus on, just learning essentially how that would go.
Great. Did we get anything in the chat?
Nope, not yet.
All right. All right, well then let's get started.
So all of family law, sort of child custody issues kind of start and almost end with the factors. And those are in your handbook. And we just wanted, Arly and I thought it was really important to kind of go through each factor and make sure that we kind of clarify, talk about how it would look in a trial. The first thing I want to say is when I have a new client, I actually hand them the factors because it's hard for clients to know what's important and what's not. They're sort of in the middle of this, horrific battle oftentimes, and, they may think, something that isn't important is super important. And so this sort of clarifies for them what they can focus on.
And while it may be important to them, frame it as the court is not going to look at that. The court is restrained to looking at these things. Often matters of finances are really important to a client. He's not paying support, and validate that. That is really important. We can talk about child support, or we can send you back to VIP to help you with that. But in custody, we're not talking about who's paying for Pampers or whatever.
Right, that's a good point, yeah. So, going through the factors, and I'm gonna just read, and then Arly and I are gonna sort of throw in our ideas, right?
Yeah, and I will highlight, there may be some people online who have taken a custody case or two. There was a law change in August of this year called Cadence Law, which did change the factors. So if you're looking at older materials, make sure that you have things that are updated as of mid-2024. Because they're reordered, new factors were added, new language was added.
So, 5328, factors to consider when awarding custody. A, factors. In ordering any form of custody, the court shall determine the best interest of the child by considering all relevant factors, giving weighted consideration to those factors which affect the safety of the child, including the following. 1, which party is more likely to ensure the safety of the child?
So this is the new factor 1. It used to be about cooperation between parents, and Hayden's Law, which was enacted, is specifically targeted at protecting the physical safety of children. And so this is primary in the court's mind, and we really look primarily looking at who is going to ensure the physical safety. They do look at, emotional and psychological safety, but really the courts are looking at physical safety. So if there has been physical harm to the child, the court wants to know about that. If the dad drives the car without putting the child in a car seat, the judge wants to know about that. Are there things that are going to put this child at risk? The court really wants to hear about those things first and foremost.
The past and present abuse committed by a party or member of the party's household, which may include past or current protection from abuse or sexual violence protection orders where there has been a finding of abuse. And under that, it says the information set forth in 5329(1)A relating to consideration of child abuse and involvement with protective services, violent or assaultive behavior committed by a party, and which party is more likely to encourage and permit frequent and continuing contact between the child and another party if contact is consistent with the safety needs of the child.
So this is the domestic violence factor. If your client has a protection from abuse order against the other party, or if the other party has a protection of order against your client, if a party has been convicted of a crime of violence of the other parent, those are things that the court has to look at. And in 5323, there's a new part of Caden's law. If there is a finding that there has been abuse by one parent against the other parent, there is now a presumption for supervised custody for the parent who has committed the violence. And so this factor now has the weight of a presumption behind it, and the parent who has committed the abuse has to overcome that presumption to overcome supervised physical custody. There are some tricky parts to this, including, what is abuse? Often in Philadelphia County, protection from abuse orders are entered by agreement. If there's a PFA order by agreement, there's no judicial finding, and therefore you're gonna have to prove abuse again at the custody trial because there is no judicial finding from the PFA. So just because your client has a PFA order doesn't mean it's gonna trigger the presumption or that this factor is gonna weigh in your favor. You have to look at how that PFA was entered. If it was after a trial, that means that there was a finding of abuse and that triggers there's a judicial finding of abuse. So make sure you're looking into what your evidence says about the abuse. In addition to DHS findings, that is here in the sub factors under 2. If there's been a finding of child abuse by DHS, you have to reprove that. Because it's not a judicial finding, it's an administrative finding. And so it's important to get those DHS records, but you may have to have your client testify again about what happened or call the DHS worker and present testimony for that. So when you're looking, don't assume that your abuse is kind of slam dunk because you do need to have it to the level of a judicial finding for a judge to be able to rely on that to make the presumption happen. And one more thing, this is like my area. I'm at PLA, we focus on domestic violence. You'll see factor 2.3. This used to be its own factor of which party is more likely to encourage continuing contact between the parties. This factor had language updated to say that it's consistent with the safety needs of the child. And this is addressing allegations of alienation by the abusive parent. And so this factor specifically carves out that if you are protecting the child from violence, that is not parental alienation. And so make sure that if there are some sort of allegations that a parent is keeping the child from the other abusive parent, you can highlight that the new law says that parents should be protecting their children, and that is not alienation when there has been abuse and their safety needs.
That's a really delicate issue because of oftentimes you will see one parent trying to alienate the other parent, and now it's easier for them to do that. So sort of taking the opposite perspective, I've seen it work against a client, oftentimes a father who is trying to reunite with his children or have more time with his children.
And I will say, the courts don't like it when any parent cuts off contact between the other parent. And if you are the attorney representing a parent who has cut off contact, you're starting from a hole. You have to work your way out and prove that your client was doing the right thing, because the judges kind of are assuming it's not right.
Again, I sort of take, often work with the opposite party, so what I see is you're sort of at a disadvantage if you've been alienated, because you're not privy to a lot of information that you need about the child, and you don't have the relationship with the child. So it's just a delicate balance, and obviously the most important thing is to protect the child. But yeah, it's just a delicate balance, so be aware of that, yeah.
Yeah.
All right, so any more for
No,
that?
go on.
Yeah, okay. Number 3, factor number 3 is the parental duties performed by each party on behalf of the child. This has not been changed. That remains the same. And you wanna think about things like doctor who takes the kid to doctor's appointments, who goes to the parent, the school, meets with the school, with the teacher, who. You know, takes them to certain activities, that sort of thing.
Who does homework?
Who does?
Yeah, those kind of things.
Mhm. And, you know, be aware that. Both parents will say, well, I do the more important thing, so, you know, keep that in mind.
And for like evidence, for parental duties to
Mhm.
ask your client to provide, you know, they're gonna say, I do the parent teacher conferences. And often, our clients have children who have like IEPs. IEPs are signed by the people present, so you can easily prove who was at the IEP meeting and who wasn't, if you just ask for the IEP. Doctors, after visit summaries often will say which parent was present. And so, things like that, you can get corroborating evidence to show which parent is actually doing those things.
And again, the other side, I wasn't expecting this when we prepared, but the other side of that is you can also look at that medical record and you could say, wait, why isn't one parent on there? Is this a sign of alienation? Or was that parent invited to the IEP? Why isn't that parent on the school record? So another piece of evidence is who's on the records and who isn't. Okay, next one, the number 4, the need for stability and continuity in the child's education, family life, and community life. Except, and here comes the protection again, except if changes are necessary to protect the safety of the child or party.
So looking at stability, sometimes the court's gonna look at what has the child been doing? Has the child been living with one parent, going to the same school for many years, living in the same community for many years? And is the other parent saying the child should move with me across town, change schools? The court is gonna say, well, that would not be stable. So generally, we're looking to increase stability for the children. And so if you're asking the court to change custody in a way that would undermine the stability and the continuity in their life, you're gonna have to have a really good reason.
So, yeah, the court has this sort of balancing act and it's difficult because they start out by wanting both parents involved. But if one party sort of has everything there, you know, it's their family is more involved than the other, and their school is more involved, and their community is more involved, it's a tough balance. All right, the next one is the availability of extended family.
So just ask your client, who's in your child's life? Is grandma the one that picks them up from school? Who's there? And on the opposite side, what is the other parent's family's involvement like? Or are there any concerns with the other parent's family?
Or will the other parent have concerns with your
Yes.
family too?
Yeah.
Yeah, a lot of times it's sort of this balance, because your client is gonna wanna tell you all the great things about their family or their life or all the great things they do. So sometimes I'll ask, what do you think the other side's gonna say about you? And then you prepare for that.
Most important question. And I love to frame it as, assume the other parent is gonna lie. What lies is the other parent gonna tell about you? Because often if you're like, what's the worst thing they're gonna say? They don't necessarily wanna tell it. And so you can kind of give them the out of, I'm sure it's a lie. I just wanna know what the lies are gonna be.
That's a great idea, because you do hear a lot of lies in court.
You hear a lot. You don't know if it's a lie or not.
Yeah, well, that your client says is a lie for sure. Child sibling relationships, I definitely would emphasize exploring that. That's important to the court. The court is not, if a kid is really close to their brother or sister, court is not gonna wanna tear that relationship up.
And especially with stepbrothers, stepsisters, like if dad has his other children with a different mother every other weekend, they often will want to sync up the weekend so that the step siblings are all at dad's house at the same time. So it's important for you to know those schedules.
Mhm.
Or if for some reason like dad lives in a 1-bedroom and he has his 2 children every other weekend, but there's not room for this child, and if all of the children were together, they're gonna have to trade off. So think about kind of the logistics if there are multiple sibling groups involved.
And sometimes you really have to sort of dig through everything your client is saying to you because they may not offer that up. Oh yeah, we don't really have a bed, they sleep on the couch, but, and these are things that also the judge will care a lot about. Number 7 is the well-reasoned preference of the child based on the child's developmental stage, maturity, and judgment.
So here, get the standard operating procedures for each judge. Each judge in Philadelphia County treats child interviews differently. And it's really judge dependent. The rule of thumb is about 5 or 6 and below, the children don't have to come to court. Above 6, generally, a judge is going to want to interview them, but some judges want them there on the trial date, and some judges will set a separate time just for child interviews.
Right, and so, yeah, if you're looking for the judges, so some judges have like their protocols written out.
Some don't.
Some don't, and then you're kind of, but you know, you can call chambers and ask if you
Yes.
don't know, you can, yeah. And that's probably important. It's also important if they don't have one to call chambers and say, do you want us to bring the kids or what? Or do you prefer they don't? I mean, a lot of times I find judges don't want the child to miss school.
Yeah.
So now in
And-
terms, go ahead. Oh, the well-reasoned preference of the child. So again, this is judge dependent, and I always say to my clients that, you know, judges are people, so it's sort of, we don't know how they do children, how they do their children, and we kind of have to keep that in mind. So what's important to one judge might be sort of weighted differently for another judge. So again, like judging a child, one judge might say this child is developmentally ready to speak to me. Another one might say no.
And then as far as interviewing the child ahead of time, I don't do it. A lot of practitioners do. Some judges in Philadelphia County really frown upon you interviewing a child ahead of a hearing. So I would ask like your mentor about like what judge you're seeing and how they feel about interviewing children.
And the other thing related to that is definitely tell your client not to prepare the child, because the judges are, I think, first and foremost looking to see, is this kid been prepped?
Is this
Like, and
coached?
sometimes you'll hear a kid who's like 5 say, well, in my opinion, no, it's like obvious that it's the parent speaking and the kid memorized it.
Yeah, and tell your client directly, like, don't tell your kid what to say. The first thing the judge asks is, what did mom tell you to say?
Right. Or try to end or look for what they say.
Yes.
It is funny sometimes what kids will say. In terms of attorneys being there for the child interview, attorneys have the choice to be there.
I
And-
usually waive.
Right, but
There are
I
times I don't.
agree, I will waive unless the other attorney doesn't waive, then
Yeah.
I will not waive.
Yeah,
And different judges have different ways of like where they want us, like. I've
yeah,
had-
some judges are in robing room, some judges interview the children in the courtroom.
Right. Right.
So generally, I let the children go back with the judge and have the child just talk with the judge because I find them to be more candid in that situation. But in very, very limited situations, I do think it's important for me to hear what's said, and you can either ask to be present or you can ask for contemporaneous recording, like they can have the child interviewed in chambers and have you listen in the courtroom. So if you think it's important for you to hear, definitely make sure to make that ask.
Mhm, okay. Oh, and just kind of going back again to the first clause of that, the well-reasoned preference of the child. Don't assume that because you know a kid's gonna say, I wanna be with mom, that the judge is gonna agree with that and let the, tell the parent to, that the kid doesn't have that much weight. And this is, it's important because this is for a child, so before I was a lawyer, I was a therapist. For a child to have that weight on them can last a lifetime. Like, I shouldn't have said that, or I shouldn't have done this, or I really hurt mom's feelings, or that sort of thing. So just be aware of that.
And like from a policy standpoint, we don't want like a 7-year-old making the decision of what's best for them.
Right.
Maybe a 17-year-old, the judge is gonna listen more intently. And so that's where the discretion comes in.
Mhm. Yeah. Okay. Number 8, the attempts of a party to turn the child against the other party, except in cases of abuse where reasonable safety measures are necessary to protect the safety of the child. A party's reasonable concerns for safety of the child and the party's reasonable efforts to protect the child shall not be considered attempts to turn the child against the other party. A child's deficient or negative relationship with a party shall not be presumed to be caused by the other party.
So this is the alienation factor. Truly, we could have an 1.5-hour session on parental alienation and all of its complications. I think the important thing is when there has been cut off contact from one parent or one between a child and a parent, you really need to dig into what's been happening there and be ready to present the reasons why. And if you're on the other side, what kind of harm the cutoff has caused.
Oh, and in terms of evidence, you could sort of imagine presenting evidence that sort of shows both sides of that, like one parent's been trying to get contact and it's been like not shared with the child, that kind of thing.
And on the side of the DV survivor, I often will, when I have a client who is struggling with allowing contact, I will talk to them about, okay, so what a contact would be available that you'd be comfortable with. Because judges often don't like seeing full cutoff. So I'll talk to a client, I understand you're scared. Is there a way you could do video calls from somebody else's phone number? Is there a way you could, do supervised visits? Can they visit at a park or something? And so talk to them about really kind of limited contact, because anything is better than nothing if they can do it safely.
Yeah. Number 9, which party is more likely to maintain a loving, stable, consistent, and nurturing relationship with the child, adequate for the child's emotional needs? Sort of self-explanatory.
It's family. This is where we get into the family relationships, talk about what they do together, how they feel about each other. Things like that.
Yeah, I mean, I think when have your client on the stand, you wanna just sort of describe for the court what the relationship's like. What are the things you like to do together? What is your kid's favorite thing to do with you? That sort of thing. What do you do when the kid wants to do something and you don't want to do it? It just sort of give a picture of what that relationship is like. Number 10, which party is more likely to attend to the daily physical, emotional, developmental, educational, and special needs of the child?
So does the child have special needs, special medical needs, special education needs, special behavioral needs? Are they getting services? Who is attending to those services if there are special needs? And if there aren't special needs, daily needs, you know, who's taking them to school, who's cooking them breakfast, who combs their hair, things like that.
And you gotta getting the picture that these kind of overlap a bit too, so it's when you're going through the factors and you're preparing, you're sort of like, oh, I think I said that earlier. The proximity of the residences of the parties.
So this only matters if it matters. So if dad lives in Georgia and mom lives in Philadelphia, this is gonna really matter. If they live across the street from each other, it doesn't. So think about practicalities.
And we'll be talking about relocation too, so then it matters a lot. 12, each party's availability to care for the child or ability to make appropriate child care arrangements.
So this is getting into practicalities. What is each party's work schedule? What is the child's school schedule? Are you able to pick up the child from school or are you on the job? If you can't pick up, are you able to get somebody there to pick them up? So think about practicalities of literally who can care for this child.
And sort of come prepared to say, well, I know I can't do Tuesday through Saturday, but here's what I'd like to, this is what my client would like to do on the other days when she is available, that sort of. The level, okay, and 13, which again addresses parental alienation a bit. The level of conflict between the parties and the willingness and ability of the parties to cooperate with one another. A party's effort to protect a child from or self from abuse by another party is not evidence of unwillingness or inability to cooperate with that party.
So my soapbox, domestic violence is not conflict. Those are different things. But you know, if we're in a situation that is not domestic violence, but just two parents who cannot get along, who can't talk, you know, they're going through the child, instead of talking to each other. That's the kind of situation that we're looking at here. And if that's the case, you need to talk to your client about being an adult and being a parent and how they're going to help them strategize about how they can co-parent for what's best for the child. And there's a lot of options out there. There's a lot of technology available. So there are free co-parenting apps. AppClose is the free one. There are paid co-parenting apps. Our Family Wizard is really great. And if your client is low income, which our VIP clients are, they can get a waiver of the Our Family Wizard fee. And so you can get them on OFW for free, and it's those apps really can be amazing tools for parents who are learning how to improve their co-parenting relationships.
I find a lot of the judges care a lot about this factor. They're very much aware that these conflictual relationships are just causing all kinds of trauma for the kid. And my experience is they will spend a decent amount of time on sort of talking to the parents through how you have to not do this.
And something that as a practitioner you can do, you're gonna get a case and your client has been messy.
Yes.
And before you go to trial, help them clean up. Say, you've been messy, but we got a couple of weeks, start using the app now. Start showing, oh, okay, I understand now how I need to talk directly to the other parent. And so if you can come into court and say, yes, we were really having a lot of conflict, but in the last few weeks, I've been making the effort to improve, a judge is gonna love to see even just a couple of weeks of improvement. So
And I'll
tell them as soon as possible.
just chime in to say, it's also really important to counsel your client on the language they use when they go to court. Saying my child repeatedly is not a good idea. It shows a lack of cooperation and an unwillingness to address that this other person is a parent to this child.
Absolutely,
Right.
and our Family Wizard has tone monitoring. So these apps can really help if the parents choose to utilize them.
Right, right. And to piggyback off the idea of saying my child instead of our child, the other thing you often sort of have to help parents to remember is this isn't about my time with my child, it's about what's best for your child. And they kind of, that's a different orientation for them, and I find that you have to remind them of that repeatedly, so. The history of drug or alcohol abuse, this is number 14, the history of drug or alcohol abuse of a party or member of a party's household.
So Philadelphia Family Court has urine testing available on demand at court, so you can ask for a urine test. If your client has some history of drug or alcohol use, make sure to ask your client to have the prescriptions that they're taking ahead of time, even if it's not abuse. If something's going to come up on that panel, you want to show that they're taking their prescriptions as prescribed. Opioids are unfortunately an issue. The family court can break out some opioids. But if you need to get, like, if you have a client who is in methadone treatment, or the other side says they're in methadone treatment, but your client is like, he's using in addition, and you need to pull out that full opioid panel, you're gonna have to get a special order from the court to go to a special lab that can pull out that full, the full panel on that. So it's important to know what level of drug testing family court has available, which is, it's like a 7, I think it's a 7 drug panel. And if you need more sensitive testing, you're gonna have to either do a written motion or make an oral motion before the court. And then as far as alcohol, the urine panel, pulls out the last 24 hours, but if there's a concern of significant alcohol use, you're gonna have to ask for a hair follicle test, which is at an outside lab. And then if there is alcohol issues, there are great programs like SoberLink. And SoberLink does have a low income offer. It's not free, but it is a lower pay so that people can use like breathalyzers before their custodial time if there are concerns about alcohol use.
And then the other party with SoberLink will get an immediate notification if there's some use going on at that time.
So one thing is just like when you're doing family law and things like that, there are all these really great tools. So contacting your mentor when you're like, oh man, this is the first time I've had an issue with alcohol. I don't know what's out there, reaching out to a monitor or a mentor about like, what are the options? Instead of just showing up and being like, we have an alcohol problem.
Now, this is actually a question for you, Arly. My experience has been that if one person says I want a urine test.
Both parties get
Both.
tested.
Yeah.
Yeah.
Okay.
It's always, if one person's getting tested, both are getting tested. So I always ask my client, when you are tested, what will be positive? What's gonna show up on that? And often it's something, and it could be a prescription, which is fine, but we need to know ahead of time.
And number 15 is the mental and physical condition of a party or member of the party's household.
So are there mental health diagnoses? And the important thing is, do they affect your client or the other party's ability to parent? We really aren't trying to stigmatize mental health in family court, and there are lots of diagnoses that have really no impact on the child. And so that's what you're looking at if somebody has a diagnosis. Is it affecting the child? Is your client, and if your client does have a diagnosis, are they in treatment? Are they compliant with their treatment and their prescriptions? And have there been any issues? Something that may come up a lot is a history of involuntary commitments or voluntary commitments. I see a lot of mothers who have had kind of mental health issues around postpartum depression. And just because there's something in that history doesn't mean that it's currently an issue. So try and destigmatize it and say, you know, I understand you had postpartum depression. Your kid is 7. Like, you haven't had issues in the last 6 years. And so if the other party is trying to weaponize mental health, just come at it from that place of, what is this diagnosis saying? Like, how is it affecting your child right now?
Yeah. Oh, the one thing I just wanted to add back to the drug and alcohol history is, if a person is in recovery, that's also important to know, and to sort of explore that a little. What's your recovery program like? Are you going to AA? Are you going to NA? And I think the judge would be very happy to hear that this person, yeah, had a history of substance abuse, but is working a good program of recovery.
Yeah, the thing about family and custody is the past matters,
Mm.
but the present matters. You know,
Mm.
we want to give people opportunities to improve. We want to see people in having good relationships with their children and taking better steps. And so framing it as like, it's okay, things happen in the past. What are you doing to improve?
And number 16 is any other relevant factor?
So something the judges want to see or hear about often is housing in Philadelphia with poor clients. Often they're just, housing is an issue. So ask your client, do your children have a bed? If not, ask them if they can get blow-up beds. The court doesn't need the children to be in the best housing. It has to be sufficient. And so don't be afraid of poverty, but make sure that the children have enough space and shelter to meet their basic needs. It's okay for children of opposite genders to be sharing a room if they are young. The older they get, the court may have more concerns about that. So just ask questions about housing and things like that. That comes up a lot.
I don't know if we need to go through. The A1 and A2 are also new and are sort of a result of Caden's law. Just to say, there's also B, which says gender neutral in making a determination under this everything. No party shall receive preference based upon any gender. So it's something to think about.
So there's no presumption that the child should be with mother.
That's kind of the, yes. And the other thing is the determination, says that there's no single factor that is determinative. It's the whole thing. The court's looking at the whole thing. And in fact, when you have a custody trial and you get the results of that, the judge will go through each factor and will say, well, this factor weighs towards mom, this factor weighs towards dad, that kind of thing.
All right, so we have like a 40-page presentation and we spent half of our presentation on the factors.
But we
And
plan to do that.
We did plan to do that because this is how important they are. Like, this is what the judges need to know to make a decision about custody. So we're gonna zoom through the rest, all right? So definitions. Yeah, so legal custody, who makes decisions about the child, major decisions. This can be shared between both parties or one party. All of your clients are gonna say, I want sole legal custody, and you're going to explain to them that that is unlikely to happen. And let's talk about reality. Can you make these decisions together, even if it's unpleasant? Physical custody is who has possession of the child. Primary, the child lives with you more than 50%. Partial used to be called visitation. It's less than 50%. That can be really varied. Anything close, like 3 days a week with one parent, 4 days a week with one parent, is still partial primary because it's not fully 50-50. Shared is 50-50. And then partial custody can be supervised or unsupervised. Supervised physical custody, there's 2 options, professional and non-professional. Non-professional means like grandma is going to be watching the other parent while they interact with their child. If it's a non-professional, like grandma, that person has to present to the court and sign an affidavit of accountability saying they're gonna do it. The other option is, Philadelphia has a, supervision site at West Health Centers. That is located in North Philadelphia on Broad and Lehigh. You go there on Saturdays, drop your kid off. The child, and the other parent are watched while they interact, and there are reports that are sent to the court and to the attorneys. I've been there. It's a nice place. It's way better than the court used to be. There's toys, there's food. It looks like a daycare. So it's really an okay place for children to be. And then, can we go to the next jurisdiction? So file in the place that the child has been living for the last 6 months. There is a uniform jurisdiction law. Basically, 2 places can't have jurisdiction at once. If there's a question about jurisdiction, ask your mentor because it can get complicated. Standing, so who can file for custody? A parent, there is a new case out of Supreme Court from Elise's firm about who is a parent. It's a fun area of the law that's developing. Someone who stands in loco parentis, which means acting as a parent. To be in loco parentis, you need to discharge parental duties, assume parental status, and you cannot assume in loco parentis status with against the wishes of a biological parent. Grandparents have special standing, so grandparents who are seeking primary physical custody can have standing if the relationship began with the consent of the parent. They're willing to assume custody. Those 2 are always kind of there. The ones that that people get caught up on are the child has been declared dependent, or they're at risk of they're at risk because of drug or alcohol abuse or neglect, or the child has been living with grandparents for 12 months and has been removed. So if you are representing a third party, then there's one more standing. This is a newer standing. Third party standing applies to anyone, like a neighbor or soccer coach. You can have standing if you're willing to assume responsibility of the child, you have a sustained sincere interest in the child. Those 2 are always hit. The one that you are gonna have to really prove is that neither parent has any care or control of the child. And this doesn't apply if there's dependency actions happening. When standing matters, if you're representing a non-parent, you have to prove that your client has standing. So you're gonna have to show they meet these criteria. Or if you're representing a parent and a third party is trying to get custody against them, you're gonna try and fight to say that they don't have the right to do that, and you can file a motion to dismiss for lack of standing. Those motions can be filed at any point. So even if you get a case that has been we're almost to trial or whatever, and you're like, wait, there's a standing issue. Don't worry, it doesn't have to be raised in preliminary objections. You can raise it if you see it.
Yeah, so if you get a case where standing is an issue, I always sort of say, wait, we gotta. Before anything happens in terms of custody, there's this sort of higher level that has to be addressed. Cause sometimes like you'll get a grandparent, it's like, no, we have to look at standing first and we have to prove that to the court.
Yeah.
So.
It's a threshold issue. Right. Criminal convictions. So if either parent or a household member of a parent has a criminal conviction listed in 5329, the court has to make a safety assessment. That can often be done just by asking a parent, do you have concerns? If it's a conviction, a simple possession of marijuana from 20 years ago, the court has to make the determination. So they have to say, I see that the other parent has a conviction. Ma'am, are you concerned about this for the safety of your child? And the mom will be like, no. But if it's a more serious issue like child sex abuse or crimes of violence, the court can send out the parent who has been convicted to outside evaluations. Those are costly, and they will delay a case.
And just to be procedurally, when you go to custody court in Philadelphia, and this doesn't happen in all the counties, but in Philly, they will hand you, each client a criminal conviction brochure paper, two-sided paper, right? Which you just, it's a check off box.
At filing,
Yeah.
you have to disclose if you have a criminal conviction or if you know of the other parent's criminal conviction.
Mhm.
Honestly, they're not that great and the court is gonna do their own, they're gonna run criminal convictions, themselves.
Mhm. But then you do it again every time you're
Yeah.
at court, yeah, and your client's like, I did this already.
So DHS involvement in Philadelphia, the Child Welfare Agency is called DHS. In other counties, it's CYS. In New Jersey, it's DIFUS. So just know your acronyms. If there has been involvement, you want to know about it. In Philadelphia, you can get those records pretty easily. You just need the client to sign a release, and then you send a request to DHS to get the records. It's important to know what's going on, but often a lot of our poor clients have had DHS involvement and many of the investigations are unfounded, meaning that somebody called in a report, DHS goes out, they investigate and they say, this isn't true. And so they just close the case. That's the extent of a lot of it. But if there is a finding that there's been abuse or neglect, the court's gonna wanna know what happened.
Relocation, so relocation is sort of complicated, and it's sort of an area all of on its own. It's under 5337. And all I'm gonna, we can, if there's time, we can go into it more, but you really want to carefully follow the procedure, which is written out pretty clearly in the.
It took me a long time to memorize it, because there's like, I've been doing this a long time, but for the first few years, I would have to go to the statute and read it every single time. Okay, step one is this, step two is that. There are like filings and wait periods that are required, so just go to the statute and read it if you are initiating a relocation.
Or if you have a bad memory and you just keep doing it every so often. So, once you, assuming everything goes well and procedurally you followed it, then there's relocation factors. Which you're gonna also wanna review super carefully with your client. And you'll see that they sort of kind of parallel the custody factors, but there's sort of kind of don't, just to make life a little complicated. But again, just like with the custody factors, you wanna reference them and be aware of them and sort of understand how the court's gonna prioritize. The other thing, there is a presumption in the court against not relocating, so the party proposing relocation has the burden of establishing that relocation is gonna serve in the best interest of the child, so.
And relocation has a pretty specific definition and the court has to decide, is this a relocation or not? And basically it's any change in residence of the child that would impair the other parent's custody rights. And so generally we're gonna say if you're moving a house within Philadelphia, like if you're moving from west to south, it's not a relocation. If you're still kind of in Philadelphia. If you're leaving the city, even if you're just going to the suburbs or you're going to Cherry Hill, that's gonna be a relocation. The child is changing school districts. There could be long drives. So you wanna talk to your client about, is it a relocation or is it not if they're moving? And then when you're doing a relocation, the difference between moving to Cherry Hill in a relocation and the difference between moving to Georgia is big. Because one of the big things that the court is looking at in relocations is how do we maintain the relationship between the child and the non-relocating party. And so if it's Cherry Hill, you might be able to keep the same schedule, like if it's weekends and weeks, and really you're talking about changing schools and medical providers, things like that. the court is gonna be saying, okay, is this a better school? Is it a better house? Okay, you're still gonna see dad every weekend. It's not as big of a lift for the relocating party. If they're moving to Georgia, the questions that you're gonna have to ask your client before you get there, how are they gonna see dad or mom? You know, are you gonna pay for the flights every spring break, every summer, every winter break for the child to fly back up here? And if that's not realistic, the court is gonna have a lot of problems of you taking a child away from the other parent. For evidence in a relocation, the court wants to see where the child's gonna be living in the new spot, where they're gonna be going to school. What kind of resources there are in the communities, maybe some things about like crime statistics. And if you're moving out of Philadelphia, everywhere looks better. Almost. So those are the kind of things that you're gonna wanna talk about. And if there's a good reason for the move, you know, did you get a promotion?
Right. Okay. Now,
Procedure.
procedure, this is
I'm gonna
Arly's.
fly through this. Okay, so to start a custody case, you file a complaint for custody. To file, you can, most of the cases you're getting from VIP, the parties have already filed. And so the only thing that if they've already filed, you wanna get a copy of that complaint to make sure that, it has the right ask. Cause often a client will file it pro se. And they'll put in that they're asking for shared, and then it turns, they call you and they're like, I actually want sole, legal and primary. And you're like, well, we're gonna have to file an amended complaint. So.
Chime in, we do try to make sure we get all of the documents before we assign the cases to the volunteers.
Awesome. So you're usually not filing a complaint in a VIP case, but you do want to read it and make sure that you don't need to file an amendment. Once you file the complaint, the first step is going to be seeing a custody hearing officer. Custody hearing officers are judges, or not judges, they're attorneys who work for the court. Hearing officer events are really varied about what's gonna happen. And it's kind of hard to prepare because you're like, what is gonna happen at this thing? And I never know. Done a million of them. So often it is going to look a little bit like a mediation, not a real mediation, but they'll see if there's a way for the parties to make an agreement. So if we can make an agreement, either temporary or permanent, the hearing officer will take that agreement and make it into an order, either temporary or permanent. If it's a final agreement, great, you made the agreement, you don't have to come back to court, you get your order. If it's temporary, they'll do the temporary agreement, set you for a trial with the judge, the agreement's in place until you go to the judge. If there's no agreement, the hearing officer has a choice about whether to do nothing and set you for a trial with the judge, or take testimony, have a record hearing and recommend an interim order to the judge. The situations in which they will have a record hearing, it's your best guess. And so if you need an order right away, you're gonna have to advocate and convince that hearing officer. There's the regulation says compelling circumstances, but there's no definition. There's a good reason, immediate need, we need an order right now. So we can skip ahead a couple times. After your hearing officer hearing, if your case is not resolved, you're gonna go to a judge hearing. The only other thing is if you're only having a hearing for partial. So everybody agrees who has legal custody and who the child is going to live with primarily, but the parties are just unable to decide on what one parent's partial physical custody looks like. Say mom has primary, she wants dad to have 3 weekends a month and dad wants 4 weekends a month. There's no agreement, but the only issue is partial. That is heard by the hearing officer only. And so you'll have a record hearing with the hearing officer, and then the hearing officer will create a report and recommendation. After the hearing, that report and recommendation is sent out to all the parties, and you have 20 days to file exceptions if you're not happy about it. The exceptions are like appellate kind of argument, they made a error of fact or law. The exceptions are heard by a judge. It's not a new trial with your judge. They made an evidentiary hearing error, not letting me present X, Y, and Z evidence, or they didn't apply the factors correctly. You're making only allegations of error of fact and law. So if you're only arguing about partial, your actual trial is with the hearing officer. So then hearings before a judge. I feel like we've talked about it, but you show up to your judge, and we're gonna talk more about this. Before you see your judge, you're gonna negotiate with the other side. You're always gonna try and get an agreement, even if it's a partial agreement. We can agree that we should have shared legal custody, but we can't figure out a physical custody schedule. So try and do an agreement, see what you can get done, and then you go in and you present your factors to the judge.
So, in terms of prepping your client, you do want to sort of talk to them about the language they use, not my child or my time. You want to talk to them about what they want to look like at the hearing. Do you want to show respect? Don't go in ripped up jeans, that kind of thing. Your demeanor in front of the judge, be respectful. The other thing that I think is super important, people are really suffering and they want their day in court. And the truth of the matter is they're not gonna really get it. Oftentimes they'll be lucky if they get, an hour in front of the judge.
If that.
Okay. So really kind of get them ready for that, I just want you to know you have so many important things, but we're not gonna be able to present that to the judge. Let's try and pick and choose and just be prepared. But it's really hard, like you're really worried about your kid and the judge just doesn't have time to hear it all. So.
I'll tell clients, prep them, it's going to be unpleasant. So they know, you're gonna be talking about deeply personal things. The other side is going to be able to ask you questions. They might lie. It's gonna be upsetting. And so prep them for that and try and help them say, like, if they lie, it's important for you to stay calm because the judge is watching you the whole time.
Yeah, and yeah. One of the things I had in an interesting case was I had a really great witness and prepared, not witness, the litigant, and we were well prepared for trial. But he was so afraid during the cross, so during the other side, that he was gonna somehow be tricked or something like that. So you want to prepare your client both for direct testimony, but you also want to prepare for cross, because you don't need to be defensive. And like Arly's saying, the judge is watching. You don't want to look like no, I didn't do that. No, I didn't, you want to you're just an honest person telling your story, and that's okay. The other thing I would recommend to your client in terms of going before the judge and when you're in testimony is some attorneys, and I'm sure you've seen, will just try and cut your client off, like, want that yes or no answer that we learned in law school. It is definitely okay in family law, in my experience, to say, Your Honor, I wasn't done answering yet. I'd like to finish my answer. And I find most often the judge will want to hear it out. Yeah.
When prepping your client for cross, right? Like, you do need to prep them for direct, but you need to prep them for cross. I will explain to the client that the other attorney they're trying to get you upset. They're trying to confuse you, and their questions may seem probing and maybe inappropriate. And I'll explain that my job is to protect them if the attorney is asking something that the law doesn't allow. But that otherwise, if I'm not saying something, the attorney is allowed to ask it. and that the client should answer truthfully and try and stay calm.
Right, and the other thing, so sort of in terms of direct, is to. I like to prepare, you may not have as much time as I do, but I like to kind of really practice a direct, and I also remind people, don't go beyond the question. Cause sometimes you're sort of, oh, shoot, why'd they say that? I just wanted to know this, you know? So kind of practice what you can say, what you might wanna say, what you might wanna point out to the court, but also that you don't need to say more than that.
And when you're practicing with a client, it is practice. And so if they give a bad answer, you can tell them that answer was too long for this
Mhm.
question that I asked. Try and keep it to just that first part that you said. And you can, it's participatory. So you can tell a client, if I'm asking a question that the way I ask it is not how if you need me to ask it a different way, I can. Are you comfortable with me asking you about certain things? Especially if a client has a history of some sensitive topics like domestic violence or mental health. I will ask them, like, how much detail do you want me to get into when I ask you questions? And I will explain the law says that the judge needs to hear a little bit, but if you're not comfortable disclosing everything, you know, it's your case. Here are the pros and cons about giving up this stuff. So when you do have sensitive topics, make sure that you're giving your client agency about how much personal details to disclose, because this is their lives, this is their case, and it's your job to tell them how you think this is going to affect the outcome. But ultimately, I choose to give clients the power to make decisions, as long as it's within the law.
I agree wholeheartedly with that. I think you did the exception.
Yeah, I did exceptions. We did regular, okay, so, generally, you're listed for about 45 minutes when you have just a regular trial. If you need more time than that, you have to file a written motion asking for either a semi-protracted or protracted. Semi-protracted is half day, protracted is 1 or more days of trial. And the judges on a custody day, they have 15 cases listed in the morning. And so they really don't even want you taking 45 minutes. So even though we spent 45 minutes just going over the factors, you could present hours and hours. This is people's lives. There is enough evidence. You as the attorney need to figure out how to be concise and persuasive. Even if your client says, we need to present everything, you have to make choices. You can ask the CCM if there are multiple cases like a PFA and divorce or something, you can get it all before one judge.
And that, yeah, that's a consolidated case management, and you have to.
A written
put
motion for that.
Motion for that, and that's also useful if you have like a case that's always going back before the judge, so.
Yeah, so
Volunteers, just so you know, if you're doing a one-off and it's a one representation, we don't advise doing this.
Yeah.
But if you do, you would need also a new representation agreement to extend it to any.
yeah, often if you
Right.
see CM, you're gonna get attached. So talk to your mentor before filing a CCM.
And check in with VIP. I think
You
I.
don't want to
might-
get attached and,
Yeah,
yeah.
I think I've pulled that off.
All right, expedited custody relief. In Philadelphia, it is a slow bureaucratic machine. It's generally close to a year, from filing your complaint before you get to a trial with a judge. Unfortunately. In people's lives, time-sensitive issues come up, and the mechanism the court has to address time-sensitive issues is by filing an expedited petition. Expedited petitions are filed on time-sensitive limited issues. It is not to get an earlier court date. It is, my child needs a passport because a grandmother died and we need to go to a funeral. It is, my child needs a vaccine to be able to be enrolled in kindergarten, and there is a disagreement about vaccines. So it's a single issue, not it'd be better for the kid to live with me, it's passport. It is like a medical decision, a school choice decision, and they are time sensitive. These have to be decided now. So in deciding whether to file an expedited, you really have to decide, is this a time sensitive limited issue that can be heard at a 5 to 10 minute hearing? That's as much as you get in an expedited. And then it's about 6 to 8 weeks after filing to getting a hearing date. So it's tough even on time sensitive issues. It's just a very heavy caseload in Philadelphia, and there's just waits. There is an emergency custody option. It is super limited to, it has to be decided today for the safety of the child. Generally, very significant safety issues, If there has been cut off access between one parent and there is a safety concern, generally you're not going to get an expedited or an emergency hearing just because you can't see your kid. That's more of an expedited issue, but not even often expedited. Like sometimes they just say, wait for your trial. Or if there's some sort of like medical emergency, sometimes like the child's gonna get their medical insurance cut off for whatever reason, and you need a change in legal custody to make sure that the kid maintains their medical insurance for their special medical needs or something. That could be an emergency, but.
Or you think that one of the parents may take off with the child to
Yeah.
a different country or.
Prevention of
Yeah.
abduction, so really emergencies, don't file them unless you have to, is the feeling there.
Yeah, they really like cut.
I mean, you can
They-
try, but
you
they're
could
just gonna
try,
deny
they're
you.
just gonna deny it, it's a lot of work.
And it's a lot of work, it's like 8 hours of sitting around, so, your client always thinks that they have an emergency. And it's an emergency to them, but it's not an emergency to the court, and you're gonna have to explain that.
And support them, like,
Yeah.
you know, I get why this is so important to you, but unfortunately, the court won't do anything.
You can file a petition for contempt if the other parent is violating a court order. The thing about contempt is everybody wants to have the other parent found in contempt, but the sanctions for contempt are not what people want. So the sanctions for contempt are in statute, and they are things like suspension of licenses, fines and fees. There can be incarceration, but only incarceration with a purge factor. So you're incarcerated until you produce the child. So it's not just flat incarceration. And when you talk to a client and they're like, he's violating the custody order, you're like, okay, do you want him to pay a fine? Usually they're like, no, I want a different custody order. That's not what contempt is for. That's what modification is for. And so you can explain to the client that we can file a contempt. This is what the court can do if the other party is found in contempt, or we can file a modification and get you a new custody order. Modification of custody orders is not a sanction for contempt.
So I'll just chime in too, that VIP typically does not take contempt hearings for direct rep.
Yeah.
If we do have a contempt case on our website, it's usually for advice only, and even then it's not on the website, we usually have very specific people we ask give advice to clients.
This is really an advice issue of your client is gonna, when you're prepping, they're gonna say, he's been violating the order, or she's been violating the order. You're like, okay, how do we work in that behavior into the factors and explain like this is showing conflict, or this is showing he's not addressing the daily needs. And that's why we need this custody order that we're asking for, not to file a contempt and have, his driver's license taken away. So really, that's where, when somebody is violating custody order, figure out how to get the behavior of the violation, fit it into the factors in your request to the court for custody, as opposed to going the contempt route.
So we have about 10 minutes. I just want to check if there are any questions so we can sort of time it right.
Yeah. I think we talked about kids during the factors. So we can skip ahead.
Oh, that was just.
Oh,
Okay.
yeah, keep going. So, motions and continuances. If you need a continuance, there's, a policy on how to do it. The thing about continuances is if you get one, you're back of the line and you're just gonna have to wait a really long time. So if, you know, it's slow moving over there. And motions and petitions, we talked about, some of them, motions for, drug, motions, for home investigations. There is no discovery in custody except for by court order. If you need discovery, file a motion, say this is what I need discovery for. Otherwise it's trial by ambush. All right, agreements.
Okay, so I think we described enough about what it's like in front of a judge to hopefully promote agreements. It's really hard for a client who has, you know, so many issues. And to know that a judge is just gonna make a very quick decision about their lives, and so. A lot of times your client will be like, I am not making an agreement with this person's a jerk, whatever. And you say, well, you know, if you choose not to do that, the alternative is that somebody else is gonna decide, and this person who's gonna decide is gonna know you for 15 minutes. So again, just talk to your client about the advantages and disadvantages of compromise. And obviously in some cases, it's just not an option. But I think oftentimes it is. And the reality of the situation, for example, if you don't like what the hearing officer says, you're gonna have to wait 9 months to go in front of a judge. Like, there's just a reality factor, so, yeah, I think that's like the important thing, and I would suggest that you could sort of sit down with your client and say, okay, you kind of know, dad says he's okay with this amount of custody, you're okay with this amount, but you're arguing about holidays. Why don't we have a list of holidays, and why don't you say what you want, and, you know, we'll figure out some compromise in there. So if you're lucky enough that it's a case that's arguing about holidays or vacations, which
Dream.
yeah, you know, just really work hard with a blank agreement and sort of say, what do you want? You know, how can we make this work? Kind of, sort of. And just remind them, when you go to custody court, no one wins. No one wins. That's my little spiel on that.
So I think the way to get a client to an agreement, and Emily and I both agree, agreements are such a good outcome in family court, and your client is gonna be unhappy about it. Or your client's gonna be unhappy with an order that comes after a trial too, like. Everybody is dissatisfied, everybody is unhappy when they're in custody court. And so if we can get an agreement, that is one of the best case scenarios. Getting to an agreement in a contentious custody case is going to take work ahead of time. So start by expectation setting. You are often, I see this all the time, the client wants sole legal custody because I'm the only one who takes them to the doctor anyway. That's what the clients say. And
All
so
the time.
expectation setting. I will explain that judges do not like to take decision-making power away from parents unless there is a very good reason not to let them make decisions. And a very good reason is not that they haven't been making decisions, it's that they have made decisions that have harmed the child. That is really the only time that a
Y'all are on mute.
Primary, often, you know, clients are gonna say, I will talk to clients about what's been happening. You are unhappy about the current situation, but like the other side is seeing the child 2 days a week, so why are you asking that they never see the child again? Like you've been okay with it in the past, there's been some issues, but the issues are, he's late for pickup, so maybe we could talk about the times of pickup changing, not he can't see the kid or she can't see the kid. And so really like drill down with your client that the ask that you're going for is somewhat separate from the actual issues that you can prove. And getting to the actual issues goes through interviewing with your client of like, what is actually going on? You're mad because he's always late to pick up. And so the result of that with a court is not take away his right to have weekends. It's what, can we move the pickup location? Can we figure out a different time that works better? Things like that. And so with agreements, expectation setting of the other parent, if we go to a trial, the court is not taking the other parent out of the picture.
Right.
Even if there has been domestic violence, even if there has been drug and alcohol use, even if there are mental health concerns, even if his house is inappropriate. Those are all things the court takes very seriously, but they will maintain a relationship with the other parent, just taking into account what that concern is. And so explaining to the client, the other parent is gonna have custody. What is that custody gonna look like? What would you be comfortable if we start from a place of the other parent's gonna see the kid? How would that work for you? Your concern is his house, there's no bed. Okay, he can visit during the day. As much daytime visits as he can. If your concern is drug and alcohol use, get a sober link agreement. If your concern is domestic violence, the violence against you, we can protect against that. Maybe exchanges. He picks up from school and drops off at school, so you guys never interact. You pick up and drop off at a police station, so that you're safe, or somebody else is doing exchanges if you're concerned about your safety. If there's concerns about the child's safety, we'll talk about supervision. The answer is not cut out the other parent. And these are the conversations that you're gonna have with your client to set them up for an agreement so they understand what's realistic at a trial. And so they bring down what they're gonna agree to.
One of my, another consideration, one of my VIP clients taught me this expression. Don't wake the bear. Like, if you really arguing over something that you may not even win in court. But you may end up losing more time. Don't bring the other side to court, because that person might be saying, well, I only get 2 days, you want me to have 1, I want 3, or I want 50-50. So.
Yeah, what are the
just-
risks to going to court?
Yeah,
If you're fighting heavy on custody,
yeah.
maybe somebody's gonna file for child support.
Mm,
Right, what are the other things?
yeah.
If you don't make this kind of agreement, how is that gonna affect other areas?
So we have about 3 minutes left. Do either of you have any advice or other tips that you would give our volunteers, especially our first time family law volunteers?
My advice is that the law of custody is pretty easy. We're looking at what is best for the child. The thing that is hard about child custody is we are dealing with private families and really intimate details of people's lives that are emotionally charged. And being ready to talk to a client going through a really tough situation and bring in compassion, but also bring in kind of a realistic counseling perspective is what they're relying on you for. You know, they need you to give them advice about what this process looks like, what they can expect, and that will help them feel empowered that, you know, they were heard, but why the court did what it did or why they made the agreement that they did. And that you shouldn't be afraid to take a custody case. Custody is always modifiable, like, you mess up, whatever, file them on. You can't mess it up if you are doing your best and you are listening to your client. Really, the client is gonna be better off with you talking with them, with you preparing them, than if they were there alone. And that is the option. If you're not doing it, they're doing this by themselves.
I agree. Awesome. Thank you both for joining us today. Again, we're sorry for the slight disruption, but it happened at the best time.
Yes.
Not in the middle of the presentation. There were no questions.
There are no questions.
But if you do have questions, feel free to email myself, Susan, and if Arly and Emily are
Please
available
do.
to that, we'll share their contact information as well. And thank you again to everybody that joined us today.
Thank you. Thank you.